Good morning everyone and welcome to this month's webinar in which we're going to look at the 5 key considerations when ending employment. So before we make a start, as usual, we would like to just introduce ourselves. I'm Victoria Templeton and one of the HR Knowledge Managers here at HR Solutions, and I'm going to be leading today's webinar, and I'm also joined by Abby Ashford. Abby is our lead HR consultant and will be sharing her insights into how the employment relationship ends from her practical experience in HR. And we're also supported by Drew. Drew will help us in the background with any technical problems. Hopefully we won't have any, but Drew is on hand. And because we've got lots of you who've joined us today, we've placed you all on mute, but obviously we do always like to take your questions. So when you do see this slide, that means we're at the end of the webinar and we'll be ready to take your live questions. So I'm just going to run through how you can raise a question for us. And so on your screen now, you'll see an image of what your GoToWebinar panel screen looks like. Just simply type your question in the questions pane and we'll aim to read out as many as we can at the end of today's webinar. And when you see this slide, it also means that we'll be running a confidential poll. So they're really interesting to a webinar just to see and get input from you all and to make it as interactive as possible. And so to our webinar. And so when the employment relationship ends, regardless of which party ends it, there will always be certain things that should be given consideration that's going to help the business. And that's what we're going to be talking through today. So to begin with, I'm going to set the context by explaining the various ways in which the employment relationship can come to an end. And then I'll be looking at the importance of managing the employment effectively, the end of employment effectively. And then that will lead us on to looking at the 5 key areas of people management that we believe to be important when managing this part of the employment life cycle. So it's just worth highlighting, and for context, the various ways in which employment ends, and it can be through either party. So from an employee's perspective, obviously when they resign, there's going to be certain obligations that they'll need to undertake in doing so, and from the employer's perspective, then it's about being mindful that whenever the contract is terminated, that it's done so in a way that doesn't bring risk to the organisation. And as you can see here, I've noted the 5 fair statutory reasons for dismissing. As you can see, conduct, capability, redundancy, some other substantial reason, and statutory illegality, and of course end of fixed term contracts. And then we have the 3rd way, and that's through mutual agreement, and how the employment relationship can come to an end through signing of a settlement agreement. So it's important to be mindful about how the employment relationship does end, because of there can be serious consequences if not done correctly. So for instance, perhaps there hasn't been a thorough or fair process, and that can ultimately lead to costly tribunal claims. So if you're managing a disciplinary matter, gross misconduct matter, if there's not that fair and thorough process, then that can expose you to risks of unfair dismissal claims, as well as discrimination claims and breach of contract claims that can arise when the employment contract ends. So it can lead to costly tribunal claims. If you are having to manage tribunal claims, that takes management time and effort as well, not just in terms of attending tribunals, but also all the hard work that goes in before in preparing for the tribunal. And the tribunal can be one day, it can be a week, it can be a couple of weeks, depending on the size of the claim. But even if there aren't any tribunal claims, not managing the resignation properly can also lead to additional time and effort on the part of the manager. So for example, if there's any administrative errors that are occurring, such as perhaps not paying the right holiday pay at the end and things like that, not processing things in the right way or in a timely manner, then it just takes time and effort as well on the employer to correct and put right. And of course, tribunal claims can give your business negative publicity, but you can also get bad publicity, even if someone is just unhappy with the way they've been managed and treated. It doesn't take much nowadays with social media for people to let off steam or have a moan about their workplace. So there's that public image as well that has to be considered as well when you're dealing with when somebody leaves the organisation. And connected to this, the way you handle an employee in their last few weeks of employment could see others in the workplace question their commitment for remaining with the business just by how they perceive how their colleague may have been treated. You know, they might just question, why would we want to stay if the company treats someone in that way? So it is really something to be thinking about. And in turn, all of that can lead to low employee engagement amongst those who remain. And obviously you don't want further attrition at this point. And so as we look at the 5 considerations, we're going to consider more about these issues as we go through and discuss each one. And the first one is all about planning. So planning is a fundamental part of dealing with someone leaving the organisation, whether that's to do with the end of the fixed term contract, whether it's someone that's resigned, if there's an impending retirement, or even when you're dealing with formal processes or redundancy. Planning is crucial. It's because by planning you can create a good employee experience, therefore positively impacting on employee engagement. It can also allow the business to plan in the short to medium term and even forecast future attrition. Planning is also fundamental for ensuring the business has the right skills and capabilities in the future. Succession planning, for instance, helps a business to source technical or senior roles for the future from within their organisation. And planning is also necessary for ensuring that the structure always remains fit for purpose. And if not, then it's about making those necessary changes to ensure that it does remain. And secondly, a really important management tool is exit interviews. If you don't currently do them, then we would always strongly advise that you do. And if you do carry out exit interviews, then hopefully you are obtaining plenty of meaningful data and insight into how your employees perceive the workplace. So this leads me nicely on to the polls, and we've got 2 or 3 polls here at this point that I'm just going to raise. So, and the first question is, do you carry out exit interviews? So let's see. I'll keep the poll open for a little bit. Okay, and I'll close the poll. And just let's share that, share the results. So as you can see, 84% of you do hold exit interviews, which is great. 16% of you don't at the moment, and there could be various reasons for that. But hopefully as we just go through in this next particular section, it will give you more insight and perhaps something that you may think about, something you perhaps want to introduce. So the next poll I'm going to bring up is, what do you do with the data that you gather from your exit interview? So let's keep it open for a little bit. Okay, I'm going to close the poll. And Abby, I'm going to share the results, see what you think with these results and get your thoughts as well. So 16% of you aren't doing anything with the data that you're gathering. 56% of you are analysing it, producing reports and summaries for the senior leadership team. And 28% of you use it only within your immediate team. So Abby, do you have any comments you'd like to make around those from your experience working with your clients, especially with the challenges with staff attrition and things like that?
Yeah, staff attrition and also engagement, especially in the period after the key bit of the pandemic and everybody coming back into workplaces, whether that's at home or in person in offices and it's basically the engagement part from me, and what I get to hear from our clients is, why are people leaving? Why is recruitment so hard? And exit interviews are a really good tool to find out why people are moving on. A lot of people moving on are new into post, and perhaps they haven't been embedded well. They don't feel like part of a team, perhaps because they're at home and their only interaction is on a screen. So there is so much to learn from exit interviews at the moment. And even the fact that some companies logged onto the webinar today are doing the exit interviews but doing nothing with it, that might just mean that they're not producing a report, but they are still assimilating that information and using it in some way. But I think the 56% there of producing a report and summary for the senior leadership, hopefully that shows that the information is being looked at and sort of plans being put in place to say, right, okay, we need to sort out whatever it might be, if it's benefits or if it's culture, whatever the key tools are. And if there are HR people on the webinar today, that's so key to get that data to feed into any people planning for this year and next, of what do we need to focus on, what are our top 3 areas to focus on as a company, just based on exit interview information.
Exactly, and also knowing what the recruitment market remains like, being really challenging for many employers. I think, people want to be holding on to their staff, and if there is an attrition problem, then exit interviews is a brilliant tool for helping avoid attrition. And therefore, if you're avoiding attrition, you're obviously having to not have so much of a need for recruiting replacements. So thank you, that's all.
Yeah, I was just going to say with the exit interview as well, the fact that that's almost too late in some circumstances, isn't it? Because the person's already gone out and found their next role to move on to. So, some clients are doing stay interviews. Not everybody's keen on that sort of thing, because if you open up the conversation of why do you stay with us, you might get questions about, oh, well, actually, if you're asking the question, can I have a pay rise, please? So yeah, it's not every employer wants to open that door, but having the conversations about what is good about working here, what do we need to keep doing or grow, is actually very valuable as well.
Yeah, thank you. And I'm going to call up the next poll, and it's about the timing of the exit interviews, and in terms of when do you do them? Do you do them at the point the person resigns, or on or very near to the last day of employment? And I think this is an interesting one, so let's see what the results show. Because there's pros and cons, isn't there, to both of them? So let's see. Keep it open for a little bit longer. Okay, let's close the poll and share the results. Happy? Let's see what we've got. So we've got 22% carry them out at the point the person resigns, and 78% carry them out on or very near to the employee's last day.
Yeah, and that's
in your experience, Abby, what do you say, your client base, do they tend to do them at the end or when the person resigns? Is there a general?
Yeah, definitely towards the end. So you're bound to have a conversation at the point the person resigns, not an exit interview, but certainly a conversation, especially if you want to try and retain that person by talking about pay and benefits. But if that person then is already decided they are moving on, no matter what the current employer can offer, then it's more likely that those interviews will happen towards the last day of work. It is tricky to get it right, because sometimes people sort of lose energy, don't they, and just want to move on, and then you've missed your opportunity. And you've got to factor in if people are taking holiday, or if they go poorly, are they genuinely or not towards the end of their notice period. So there's a sort of sweet spot, I think, perhaps about a couple of weeks or a month before, just to make sure that you can have that exit interview, but certainly towards the back end would be optimum, I think.
Yeah, and also I think if you carry them out as soon as the resignation comes in, how open and transparent would that person be in that interview, knowing that you know they're going to be working their notice period. So if there was anything that perhaps is a bit challenging or would be confrontational, obviously in a constructive way, then you know they may not feel open to be able to share those thoughts. But equally, if you do it at the start of the resignation, can you get them to change their mind? You know, especially if it's somebody that you actually really don't want to leave. You know, they're a valuable employee in terms of their performance, etc. And you know, that could give you an opportunity to try and address some of the issues they're perhaps sharing with you as to why they're wanting to leave. So there are pros and cons to either, and it's just interesting. There's no right or wrong. It's going to be what works best for your organisation, I think. But yeah,
and,
it's interesting to
and
see.
Depending on the circumstances as well, if you've got a dispute in place, some kind of grievance perhaps, then by having that exit interview as soon as possible, it gives you a chance to clear the air before that person moves on, which could prevent a tribunal claim coming in.
Yeah. So let's hide that. And we have one more, and then we'll move on to the next part. So that is going to be about who carries out the exit interview in your business. So let's see where we are with the votes. Okay, let's get ready to close the poll. And let's share. There we are, you should be able to see it now. So 15% of you, it's the line manager that carries them out, 82% it's the HR function, and 3% senior leaders, which probably doesn't come as a surprise in my experience. Does it to you, Abby?
No, not at all. And, you know, although employees are savvy, they will know that even if it is the HR person that is sort of slightly removed, because it's not the direct line manager, they'll know that the information will, you know, get back to those in management. But it does help having that person who is just slightly removed from the situation to have that kind of conversation. And it's so helpful, as I said before, because you get all those themes coming out of what does the business need to do from a people perspective. So no, it's not a surprise. And if people do have HR, even if it's just one standalone HR person in their company, then it's really good for that person to do the exit interviews if possible.
And I've known in previous organisations where I've worked where they have had senior leaders actually carry them out, and it's been a positive. The employee feels like their input is valued because of who it is that's hearing the exit interview and hearing their feedback. So I totally get why, you know, there are some of you on the call today that there are people managing their exit interviews in that way. So that also, you know, tells you it's a very important area for the business leadership team if you've got somebody senior getting involved in you know, people leaving and staff attrition. So thank you. So I think that's all of the exit interview polls. So I'm just going to carry on with the webinar. And really, just to summarise, I guess, from our discussions, so exit interviews are a key management tool. Data gathered is really helpful for the business to learn where improvements can be made and therefore help you prevent future staff turnover. And if conducted early enough, it can in some cases prevent the person from leaving, like I've just mentioned. And simply because you can have, you know, the time to address some or all of the issues that they are saying is the reason why they're leaving. So they are really a valuable tool. They can be undertaken by the line manager or HR, as we've just sort of discussed on that poll, and can happen at the time of the resignation or the last date of employment. So it's entirely what works best for your organisation. But some of the things I would say think about is how likely are they to be being honest with their own line manager? So is another person in the business more appropriate to encourage a more honest assessment? What are the chances of someone taking part in an exit interview on their last day of employment? They may get preoccupied, you know, with the last day. excitement? Would it be more effective as soon as they have resigned, or could that discourage people from sharing all of their thoughts, knowing that they're still working a notice? So there's many pros and cons. There's no right or wrong way. They're just things to consider from your business perspective and what you feel is right and appropriate for you. And number 3, it's all about the offboarding process, which is essentially the practical side of how you deal with an employee leaving the business. So it's like the opposite of onboarding. And I'd say there's 5 main areas to consider when offboarding an employee. You've got the resignation response, managing the notice period, managing annual leave, consideration to gardening leave, and obviously crucially the handover. And if we consider first of all the resignation response, then think about the employee experience overall, because you never know, you may want that employee to return to your workplace in the future, so it is about that experience and what you provide them as they exit the workplace. Typically, it's going to be a written response when you respond to the resignation, having that formality. Using or creating a standard template that's appropriate for your business, where it's showing that you're wishing them well with their ongoing career in their development, and just recognizing the fact that they've given that great service to the company whilst they've been working for you. Some companies provide leaving cards as a gesture, and also some, as I said, allow for senior leaders or managers to meet with them either on the last day or do the exit interview. And these kind of things generally show that you're taking an interest and you're maintaining that positive, good employee experience when somebody transitions from your workplace to a new. And then in terms of the managing the notice period, then always ensure that you check what's in the contract, because if you do have contractual notice and it exceeds statutory, then you must award the greater. Just a reminder, statutory notices, when somebody leaves within the first month of employment, you have that 1 week between 1 month and 2 years of employment. It's the 1 week, and then 1 week's notice for each year if employed between 2 and 12 years. 12 weeks notice if employed for 12 years or more. I think I've got that right. There's too many numbers in there, but you can correct me, Abby. But so yes, essentially, just make sure that you check your contract of employment, and if you offer greater than the statutory, that's what the notice period. And then sometimes employees request to leave early and not work their full notice. And what do you do? I mean, ultimately, that's an operational business decision. If you can accommodate that and allow it, fair enough, you're agreeing for them to not serve their contractual notice. That you're agreeing for them to break their own contract, if you like. So it is entirely an operational matter. And especially when you're dealing with the employment being ended by yourselves, the business, then sometimes payment in lieu of notice is appropriate. So, for example, if someone has been dismissed, your contract of employment has that pile-on clause to allow you to offer it, then they could leave with immediate effect. You're simply paying them for the notice instead of them working it. But you've got to obviously have that contractual clause in the first place to do it. And it's quite common, I mean, especially in gross misconduct situations. I mean, I've never seen somebody work out their notice. They've leaved, or in fact, it's without notice anyway. But even if somebody's on a misconduct, and a final written warning, and the dismissal is a procedural one, typically they would leave. So it's just making sure that you manage that correctly in line with what's in the contract of employment. And then when we think about managing annual leave, then have they got any annual leave outstanding at the point in time that they leave? So do you want them to take holiday during the notice pay, or do you want to pay it at the time they leave employment? If they've taken too much annual leave throughout the year, by the time they're leaving, then you're entitled, if your contract allows, to make a deduction from their final wages. But as I said, make sure you have the clause in the contract that allows you to do that. And then garden leave. I mean, this is typically probably associated to job roles that are senior, specialist, or perhaps technical jobs. and I guess you want to be more protecting of your business and from any potential risk. So the employee will still be an employee throughout their notice period. It's just that they're not on work premises at the time. They're at home in the garden is what it all stems from, doesn't it? The phrase garden leave. So the contract must allow you to enforce it. Otherwise, forcing someone to stay away from the workplace could be a breach of contract. As I said, it's typically used for senior sales, senior specialist or technical jobs. And crucially, the employee must still remain available for work throughout the time of their notice period, and all their terms and conditions remain. And then the final element is the handover, which is crucial to obviously handing over to their new replacement. If a replacement hasn't been found, then certainly to the line manager, so the line manager is fully aware of what work is outstanding, what needs to be done, the progress of any work at the point that person leaves. Excuse me. And we come now to more of a legal element of the ending employment process, and that's around ensuring that there's a fair process that's being carried out. So remember what I said earlier, that it can be costly in terms of tribunal claims if a termination process has not been followed, or if it has and it's not been a fair one. So this is really, really important from a risk management point of view. So I guess the big question is, what is a fair process? And that's a really important question, because it's one of the legal tests at an employment tribunal in unfair dismissal claims. The dismissal must be fair. But unfortunately, what's a fair process isn't a standard response in every situation. Of course, we've got some guidance, but essentially, where there's a lack of or insufficient or unfair process, that can make a dismissal an unfair one at employment tribunal. Each case is generally judged in its own set of circumstances. Obviously, we have case rulings from the past that is referenced and considered in the context of. And so we do generally have a sense of what would make a fair process from case law, from codes of practice that we have from ACAS, as well as clearly employment legislation. But it's not a defined thing. So what I thought I'd do is, in these next couple of slides, I was just going to share with you some examples of, some are really obvious, some are probably not so, about what would make a fair process. So first of all, an employer must show that the dismissal was for one of the potentially fair reasons. So your conduct, capability, redundancy, etc. That's your first hurdle you have to get over when defending an unfair dismissal claim at tribunal. And then in the case of medical capability cases, then it's almost certain that a dismissal will be unfair if medical evidence wasn't sought, or if it was deemed out of date. So before any medical capability dismissal, it's really vital that you're using up-to-date medical evidence to help you in that decision making. But what is up to date is not also defined. It really does depend on the circumstances, the health situation. But as a rough, and I mean general rough guide, you're looking at evidence not older than 3 months. But as I say, this is just a rough guide that we probably have in our minds as HR practitioners. But it really does depend on the circumstances around the nature of the health issue, whether actually you need something even newer than that. But certainly anything older than 3 months is going to be way, out of date. And therefore, how can you make that fair decision on their continued employment? If an employee raises a grievance, for example, and the grievance raises very grave concerns around the behaviours of others and then resigns, then it's vital that as part of a thorough process and for the company to take matters seriously, that all allegations are investigated thoroughly and that they're all responded to. So even though it could be the employee resigning, the company is still at risk of constructive dismissal claims. So it's really, really important when you've got a really tricky grievance that you're dealing with it thoroughly, timely, and you're really thorough and you respond to all complaints. And then the final 2 points here are around the process. And it sounds obvious, but it really is important. Tribunals are very critical of employees who don't follow their own company policies and procedures. And what's more, if processes and procedures do not align with the ACAS Code of Practice on disciplinary grievance, the tribunal can make an uplift to any award that is then made to the employee by up to 25%. And a final point on having policies and procedures: ensure that all your managers are consistent in their approach to how they're dealing with absence, disciplinary, grievance, performance, because consistency is also important for the decision-making process. And so, I mean, I've sort of said that a fair process isn't clearly defined. We've got some indications from case law, codes of practice, legislation, but there's some other, situations can crop up that probably aren't covered in the ACAS codes or the legislation, and it's for the employer to make a judgment. Oh, is that going to be fair or not? Is that a reasonable request? So, for example, you may get a request from an employee that you're working with through their long-term ill health, and they're asking for a family member to be in attendance with them at their formal absence meeting. Now, strictly speaking, from a legislation point of view, in a formal meeting where your dismissal could be an outcome, their entitlement is only to for an employee representative or a recognised trade union. It doesn't extend to family members, and that's your standard starting position. But what if that case is about a psychological mental ill health case where the individual, their medical condition does qualify, or we believe it to qualify as a disability under the Equality Act, and the nature of their health means that they get very anxious, very uptight in situations where it's like one-on-one or very small meetings, the formality of it. They might be asking for that family member to be with them as a reasonable adjustment, as a support for them, so that they can fully engage in that meeting, because without having that family member, they don't feel perhaps they'll be able to fully understand or listen or register what's being said because of their anxiety, for example. And having somebody with them might just calm their nerves, might settle them, and might be able to help with communication. So just think that when you do get requests, it's not necessarily an automatic outright no if there's some background to it, and just consider that actually it could be a reasonable adjustment. And to refuse a reasonable request like that in that sort of scenario could make the dismissal, if they go on to be dismissed, unfair. And then another example, you're trying to get a disciplinary hearing scheduled. The outcome could be a potential dismissal. So it's a very serious meeting, but you're having to reschedule it time and time again. And obviously there's generally, as a rule of thumb, there's only a couple of times of rescheduling a meeting. But what if it's now getting past that? Well, it all depends on the reason why the previous appointments have had to be rescheduled, why they're now wanting a rescheduled meeting again. But potentially, and obviously without having a specific case to sort of talk through, but potentially it could be that actually if we're having to reschedule for a third time, then because of X, Y, Z and the seriousness of the issue, you're prepared to reschedule it to this date, but within so many days. And that could be something that would help make a fair process. But there could be other practical examples. I mean, Abby, obviously from working with your client base, you're seeing and dealing with cases all the time. Are there any that you could perhaps think of that would likely see a process become fair?
Yeah, there is, Victoria, and it's interesting that in both of those 2 points on the screen at the moment, there's the word reasonable, and that can be frustrating because, you can't define what is reasonable.
Exactly.
And every single case has to be judged on its merits. And the kind of things that spring to mind for me that are current and relevant at the moment are, is it fair to dismiss somebody remotely, because so many of us are still either working from
Mm.
home completely or in a hybrid arrangement. We're often asked, yeah, can I hold a disciplinary hearing remotely if the decision is potentially going to be a dismissal one? Is that fair? Is that reasonable? And again, you have to take into account the situation. If you're a virtual company and everything is done online, then yes, absolutely, that could well be reasonable. However, if you're usually in the office, but you're taking the opportunity to do this meeting remotely just because that feels more comfortable for you, that might not be seen as reasonable. So you need to take into account the situation and other little pitfalls that come with that, because you know, if you're doing things like this in person, you get the ability to practically take equipment back that you need. You're able to complete that conversation more often than not, whereas if you're online with somebody and you're dismissing, it can be obviously very, very stressful for that person, but also very easy for them to click off the call, and then you're left in that sort of no man's land situation where perhaps you haven't delivered the outcome that you'd wanted to, and the person is no longer there to talk to and isn't then rejoining or picking up a phone call. So things can get messy, but yes, you can do things, and certainly there are lots of dismissals that now happen remotely on Teams or Zoom. And then the other one that I was actually reading this morning, just disappointedly to read, was a case with a restaurant manager who, when she became pregnant, got less and less shifts offered to her on a rota, and then and then when she became sick, absent through pregnancy related illness, when she came back to work, she was then on the receipt of a phone call where the words were, "You've been P45'd." So yes, I was reading that this morning thinking, yeah, that wouldn't be deemed reasonable, and that's not a fair dismissal process at all.
And a discrimination claim there.
Yeah, that's right. She was successful at discrimination and unfair dismissal. So yeah, those sorts of things are clearly not reasonable, but every single situation is going to be very, very different. Yeah, but those are the kind of things that spring to mind for me.
Yeah. And there is a lot of judgment to be made, isn't there, which makes it hard for employers, you know, because you're just going to have to look at the facts, weigh it all up, and try and probably have your head in the mindset of what would an outsider looking in of the situation think. And another way I was always taught years ago is, you know, think about if it was you in that situation, what would you want? Because how you want to be treated is probably how others want to be treated. So, but it can be hard. We get that, and you know, hopefully you've got your HR colleagues that are there to help guide you in any situation like that. And finally, the fifth area is around settlement agreements, which can be used purely for commercial reasons, or they can be used to genuinely protect the business from serious claims. And I'm just going to call up a couple of polls actually now. So let's see. And the first poll is around whether you use settlement agreements in your workplace. All right, so let's a few more seconds. Okay, let's close the poll and share the results. Can you see those results? So we have 82% of you do use settlement agreements, 18% of you don't. And that probably, it's not surprising. I think we're seeing more and more, aren't we, Abby? So it doesn't come as a surprise to me, that figure actually.
No, not at all.
Let's have a look at the next poll. Okay, so this one is around what, in general, what would you say is your main reason for why you use settlement agreements? Is it because as a business you're risk adverse and don't even want the threat of tribunals, even if there's not much of a case on the employee part? Do you use them because there's commonly process flaws that need addressing, and that's probably a more swifter way of dealing with it, or commercial reasons, money and time. Again, there may not be much of a case on the employee's side, but you just don't want it dragging on and on, so you use them as a way of settling. Okay, let's have a look. This is interesting as well, so let's share those results. So we've got a good mix. We've got 28% of you do recognise your businesses as being risk adverse. 19% are using them as a way to address process flaws, okay, and 53% for commercial reasons, money and time, which I get all three. I don't know, from your point of view, Abby, which one would you say, just as a general, what do you think your clients are sort of using them for? Commercial reasons, process flaws, or?
I think sometimes all three.
Oh, yeah.
but certainly, yeah.
I think it could be any, can't it?
It can, but I think it does take so much time to sort out some issues, and especially if it's a performance issue.
Yeah.
Actually, so many employers just say to me that they haven't got the time to go through, say, 3 performance improvement meetings where that person might improve for a while and then slip off again. So sometimes they just think, you know what, I've got somebody else in mind. So from a commercial point of view, this person just clearly isn't happy in post. Let's just sort this out for both sides, really. So it does depend on the situation, but I can see that the third one there, the commercial, is the key one. Yes.
Yeah. Although I've known employers to be, I guess, even though there's a commercial opportunity to settle, that they're prepared to sort of fight cases as well, because on principle. But yeah, it's interesting.
It is, and just taking that example there, Victoria, you know, on principle, people won't want to pay compensation to people who perhaps have either done something naughty or they're not performing. You know, why would you then want to compensate them for that? So yeah, that happens. And also when the employer feels like they have done absolutely nothing wrong, why should they, you know, go through a settlement process? And that's fair enough, because, you know, whilst these conversations are confidential, word does get out every now and then, and if people know that one way of moving on from a company is to try and wangle a settlement agreement and get paid to leave, then they'll push for that. So you do have to weigh up trying not to get into that kind of situation where your company culture is, okay, well, if I want to move on, I'll try and get paid to move on. Yeah, we don't want to go there.
No. Thank you. So did I share the results? I don't think I did, but there you go. Let's just hide them there. Let's hide them. Okay. So hopefully you can see the next slide, settlement agreements. So essentially it's an alternative way of parting with an employee. It could be that you're in dispute with them, there could be some wrongdoings, or as we've discussed, it could be simply a commercial decision. But what we would say is there needs to be care in terms of what type of conversation you're having that gets to that settlement agreement, because there are 2 different ways in which you can basically reach a settlement, and that's either through your without prejudice conversation or protected conversation. They're 2 very different ones, so you've got to be making sure you're using the right one. So the without prejudice route is probably the old compromise agreement that many of you may remember. This means your communications are protected by without prejudice privilege and are inadmissible in court. And for these types of conversations, there needs to be a dispute, and the conversation must be held for the genuine purpose of attempting to resolve that dispute and seek that compromise. There aren't any limitations associated it, so it can cover where there's claims of discrimination, unfair dismissals, unlawful detriment, breach of contract, health and safety matters, although TUPE claims aren't protected. You then have protected conversations, and these were introduced, oh gosh, 2013, so under section 111A of the Employment Rights Act, and their existence and content are non-disclosable at tribunal. An existing dispute is not needed where it was on the other one, but you must have agreement from the employee to enter the protected conversation. And unlike without prejudice conversations, there's limitations on the type of conversation, and really it's quite narrow in that they're restricted to when you're dealing with potential unfair dismissal cases. When conversations go outside that definition, then the contents can become unprotected and can be admitted as evidence in tribunal. And protected conversations can be initiated by an employee. It doesn't have to always be the employer. And there's a requirement that the conversation cannot be improper. And improper behaviour in that process ultimately leads to the protection being lost. And so, for example, there are general guidance through previous cases, and that's been determined through tribunal cases, of what would be improper behaviour. And it could be employer is put under pressure on considering the settlement, puts undue pressure on the employee to consider the settlement. The employee is told to enter into a settlement agreement or be dismissed. So you're giving them that very strong. If you do this, if you don't do this, you're going to be sacked. And also all forms of harassment, bullying and intimidation, that they're all examples of what we believe to be improper behaviour. So any of that can't exist when you're having those protected conversations. Settlements are complicated. They're not straightforward. They really always need HR advice and guidance around it. We do have a webinar on our on-demand webinar section on our main website, or on the knowledge base, if you're a member of that, where we covered settlement agreements probably a year and a half ago. So you can find that webinar if you'd like to find out a little bit more about them. So this brings us to the end. We're at the question stage. So Abby, just wondered if we've had any questions come in.
Yeah, we have had one. It's a good one.
Okay. Yep.
The question was, we have an employee who has consistently given her mental health as a reason for not attending meetings. We've had 3 attempts and are about to send a notification of the meeting taking place and will take place in her absence if necessary. The outcome would probably be dismissal.
Okay.
And so the person on the webinar has asked for our thoughts on that. So I've just been jotting down a few thoughts that I would like to share. Yeah, so I would want to specifically ask what the obstacle was, because obviously mental health is a very broad reason, and it could be lots of different things. It could, for example, be anxiety because of the person that is chairing the meeting. So one accommodation there might be that a different person chairs the meeting that that person has a better rapport with. So consider who is actually inviting that person, and then actually having to speak in a meeting where they potentially might lose their job. That person might be afraid that they'll sort of break down in tears, which could be very embarrassing and distressing. So it might be that that's the barrier, in which case you might want to think about, well, what location are we saying? Does this have to be in the office? Could it be remotely? Could it be at a place near their home, or actually in their home? And that's all those kinds of locations can be considered, as well as a last resort, offering for that person to submit their written submission so that they don't have to attend at all, but instead are clearly given some laid out points of what was going to be discussed at the meeting for them to contribute to, and they can just submit their not so much defence, but submit their understanding and explanation from their point of view, so that that can be completely reviewed. They could also ask somebody to speak on their behalf as a reasonable adjustment. So there's lots of things that could be considered to help in that scenario, and my advice would be to just put in a few extra measures like that in place before sending that notification that says attend this meeting or we'll hear it in your absence, so that you have a full document trail of acting reasonably prior to the dismissal. Then should that person appeal if they are dismissed or put in an ET claim, you'd be able to show that you have tried to be accommodating.
Definitely, definitely with that. And I suppose, I mean, there's limited information in the question, but if they're at work and it's just purely not attending the meeting because of mental health, then like you said, all making those adjustments to the process could be seen as a reasonable adjustment. If they're already off work and it's like a sickness meeting and they're using like their mental health is what's preventing them from meeting up, then do you already have some medical evidence on the file? How old is that medical evidence? Do you need to get some up-to-date medical evidence? So I think it all depends on the circumstances of are they in work or are they off work? And I guess also that mental health condition, I'm guessing probably the employer's known about it perhaps, or is it, I mean, it's hard to know because there's not a lot of information in that question, but everything that you've said, Abby, is spot on with terms of adjusting the process. I feel like I've just waffled then, but yeah. And what other questions have we got?
That's it for today. That's the only question we had today.
Lovely, thank you. Okay, so let's move on. Just to bring the webinar to a close, just want to share a few slides with you. Just to let you know, in a couple of weeks, we're doing our virtual employment law seminar that's free. A couple of hours of your time is just what we're asking for, but we're going to make it as interactive as possible. And we're going to take you through everything that we've got coming up in the year ahead, which if it goes to plan as what we think, then there's a lot. So it'd be great to have you join us. There's a QR code there that you can now click, or visit our website and please sign up to our seminar. So that's in a couple of weeks. For those of you that are aware, every year we run an SME survey with business leaders and in the Midlands, and we have published our latest report, which you can get a copy for free just by using the QR code here. So it basically gives you insights into what our business leaders are thinking in terms of 2023, in terms of their top business challenges, financial challenges, people management challenges, and health and safety as well. So there's some really good insights in there. So do go along and have a look, see if you can get that downloaded. We offer a lot of training courses around management training, so communication skills, leading teams, managing disciplinary grievance, etc. So do check out our training options, and if there's anything that we can help you with, we'll be more than happy to support you with your training needs. Also, we do health and safety courses, which are listed here. And just to let you know that we've got a couple of other webinars in the schedule. So the next one is around return to work interviews. Why do we do them? And then a really key one for this year is the EU law reform bill that could see a lot of legislation change at the end of the year. So do have a look. Please register to our webinars as usual. We do have a new webinar program coming soon. And what I would like to do now, if everybody's just got a moment, is just using the comments functionality, just drop us a note as to what kind of topics you'd like to see as a future webinar. And we'd really find that helpful to get your input and help us steer what our schedule is going to look like for the rest of the year. And in a moment, I'll run the last poll. Let's do this now. Okay, so if you'd like to find out more about our services, if you'd like our help in any way and would like us to contact you, then do let us know, whether it's HR, health and safety, our knowledge base, which is where we have all our template letters, policies, guidance notes, articles, any payroll support, and of course training. So do let us know and we can get in touch with you on the back of this webinar. Okay, just leave that open for a few more minutes or seconds. Okay, I'll close that. I just want to say thank you to everybody that's joined us today and for your time. We hope to see you on our future webinars and of course our employment law update that's coming up. Thank you to Abby and Drew for helping support in running this webinar. It's been really helpful to have you on board, so thank you, and hopefully see you next month. Thank you everybody.